Hello, ladies and gentlemen. So we are ready to begin with the programming. And I just wanted to remind everybody to use the Advancing Justice hashtag, it's all one word, to follow the conversation on social media, because we're currently trending right now, which is pretty cool, so please add to the conversation. So we are ready to begin. Vikrant?
Thank you. Thank you, everyone, for joining us tonight for dinner. It is my immense honor to introduce tonight's speaker, the governor of Arkansas, Asa Hutchinson. I have in front of me here the typical bio points that you read off whenever you introduce a speaker, but I'm actually not going to read directly off of them. I'm going to tell you guys a quick story that I hope will communicate to you why I'm so excited that we've got Asa Hutchinson joining us here tonight. You've heard a few times references to my former employer, the Texas Public Policy Foundation. I've talked about how much I enjoyed it there, the people I learned so much from. Mark Levin actually is right there in the front row, I see. He was my mentor at TPPF for so many years. And our biggest project at TPPF was an initiative that we called Right on Crime. Right on Crime did a lot of different things, but the centerpiece of Right on Crime was the Right on Crime Statement of Principles. This was a statement of principles that, if you read, kind of reflected general conservative philosophy, but also talked about criminal justice through a conservative philosophical lens. If you're a fiscal conservative, if you're a social conservative, the way you think about the world, how you should also think about criminal justice. And we would go around the country trying to get major conservative figures to sign on to this document. And we got Grover Norquist to sign it, and we got Ed Meese to sign it, and we got Bill Bennett to sign it, and this is very exciting. We were always very happy whenever we got these signatories. But I still remember the day that we got Asa Hutchinson to sign the Right on Crime Statement of Principles. We were on the phone with him, and we talked to him about what the campaign was about, and he was very excited to do it, and he signed on. So we went into our staff meeting, and we excitedly announced, we got Asa Hutchinson. And I remember one of my bosses going, "Wasn't he the head of the DEA?" Yeah, he was. That was a really big deal. We got Asa Hutchinson, who was not only the head of the DEA, Asa Hutchinson, who was a graduate of Bob Jones University and the University of Arkansas Law School, then went to practice law for a few years in Arkansas, and at the age of 31 was appointed U.S. attorney, youngest U.S. attorney in the country. So from the very beginning, he had a prosecutor's blood running through his veins, right? He went on, as I said, to become head of the DEA. He also became undersecretary at the Department of Homeland Security. This is a guy whose tough on crime credentials cannot possibly be questioned by any serious person. And he said, nevertheless, I'm not sure that conservatives are doing criminal justice right. I think we need to take a different approach. When people like Asa Hutchinson started saying things like this, it was a major game changer. When prosecutors and tough on crime guys like Governor Hutchinson make these points, it makes all the difference in the world for people who may be skeptical of the criminal justice reform position. That is the reason that I am so happy to have him here tonight. He is the 46th governor of Arkansas, a very strong advocate for criminal justice reform, and I'm happy to introduce him to all of you tonight and have him at this stage.
Thank you, Vikrant, for your leadership with the Texas Policy Foundation and Right on Crime. It's a delight to be with you tonight. This is an exciting occasion for those from the academic arena, those from the policy arena and public service to engage in a discussion about criminal justice. I'm delighted that we have our Solicitor General from Arkansas here, Lee. Thank you for welcoming me tonight. And Arkansas is very much engaged in criminal justice reform that I'll talk about. But let me first give a little bit more of my perspective, and perhaps it's unique. I was a United States attorney, and because I was very young at the time, age 31, it was Ronald Reagan, and that was the beginning of the drug seizures laws. It was the beginning of some of the mandatory minimums. It was OSADEF. And so it was really a very vigorous fight against drugs while I was U.S. attorney. In Congress, I saw a different perspective because I was then on the crime subcommittee of the Judiciary Committee. We had oversight responsibility, the FBI, DEA, and all the federal law enforcement agencies. The President asked me to head up the DEA, and even when I was in Congress, though, and as head of the DEA, we recognized the disparity between the sentencing on crack cocaine and powder cocaine. And I was an advocate very early on for reducing that disparity because of the unfairness of it. And then I was in Homeland Security. I went back into the private sector, and guess what? You know, the only thing about the introduction was that I've actually practiced law a very long time. And so I was a defense attorney, which I'll talk about as we go forward, and now I have the opportunity as governor. And so governor is a unique perspective among all of those, but from the policy perspective, the defense, the prosecution, the oversight, I've seen the criminal justice system both at the federal and state level. And let me assure you, I think it is an important debate. I think it is an essential debate that we talk about right sizing of our criminal justice system. It is the right debate for us to engage in. And whenever we say that, though, boy, that's a broad topic. When you say, well, we ought to be talking about right-sizing the system. But that in and of itself is important because for years, conservatives really only had one approach to the criminal justice system, and that was a tough-on-crime approach. And after decades of a tough-on-crime approach, it is a fair conservative viewpoint to say we've got to look at it more holistically. And so it was not a difficult call for me to sign on to the Right on Crime initiative because you look at the sets of principles. And my view was that these are principles conservatives ought to agree upon. Justice and fairness in our system. Second chances for those coming out of prison. Public safety obviously is an important part of the equation. But budgets and a conservative approach to financing our criminal justice system and our penal system is an appropriate response and view of conservatives. Simply the limited role of government that conservatives advocate for is relevant in this discussion in terms of the balance between federalism between our federal criminal justice system and our state criminal justice system. And it's important for me to sign on to that initiative so that I could send a signal to conservatives across the country that it's okay to engage in this debate. It's okay to reevaluate our sentencing policies to make sure we get them right. And that's just the beginning of the debate. And sometimes I notice as we go on, people see that I'm a signatory to the Right on Crime initiative, so they assume that I'm willing to support these amicus briefs that are a little bit more lenient than I would like. And so, you know, I'm constrained in my positions, but at the same time, it is a debate that is essential for our country. And now let me talk about where we've been in Arkansas and my experience as governor. As governor, when I started, and it seemed like it was a long time ago, but it was actually just about 11 months ago. But when I started as governor, we had 18,000 in the Arkansas prison system, which meant that that was at capacity, and we had a 3,000 backlog into our county jails, and our county sheriffs were not very happy about it because that was way over the limit. They were overcrowded. They were in there. It was creating a more dangerous situation for them. And so they had been advocating for 6 months in our state through the Department of Corrections and through the leadership that we had to have a $100 million new prison in Arkansas because of the prison overcrowding. When I got elected governor, I called my new head of prisons to my office and I said, I want 3 options on the table. Not one. I don't want simply the option of a $100 million prison. I want 3 options where you can address needed prison space, but we can have some alternatives to change behavior of our criminal population in the state of Arkansas. And so we ultimately decided upon a resolution that was not a $100 million answer, but it was a $50 million prison expansion in which we were also taking $14 million that we would devote to alternative sentencing courts. such as drug treatment courts in Arkansas, and expanding those for nonviolent offenders who have addiction challenges. We put money for the first time in the history of our state, putting state money into reentry programs. Now let me explain that a little bit. Historically, and of course you go back in the old movies about the Arkansas prison system, Brubaker and some of those, you realize we've got a long history with prison challenges. But for all through that time, we have historically, under the law, given someone leaving prison, whether it's 6 months, a year, 10 years, or 20 years, you give them the same bus ticket and a $100 bill and say good luck. Well, obviously, the chances of recidivism is rather great under those circumstances. And so we devoted 500 beds, it's a start, to a reentry program where they will leave prison, they will be able to go early on their early release into the reentry program where they can have help. It might be getting a driver's license. It might be being tested for and work training that they need for employment. It might be mental health services. But that was the design of the investment in the reentry program. It was additional parole officers so that we can better monitor those that are out on parole, not just to catch them, but also to help them to be successful on their parole. And the objective of the new plan was to provide public safety, but it was also to provide an opportunity for change behavior. And that was the objective, to change behavior, to reduce recidivism, to give people a second chance. The results, it's still too early to know the results because we're still implementing the reentry program. It's not fully into place. We're just putting the parole officers into place as well. We're investing in alternative sentencing courts. But we do see from the initial response, though, that our backlog of 3,000 has been reduced to 1,800. And so we hope for more success. We want this to be successful for all the conservative right reasons. And that is, it saves taxpayers dollars, it gives people a second chance, it gives them an opportunity, and it reduces prison costs over the long term. We also created a criminal justice task force, and that is the ongoing review of our sentencing policy because we're still not sure we've got it right in Arkansas. We're not sure because of the difficulty in statistics, the difficulty in analysis, the variety of prosecutors in our state and judges and sentencing patterns. We're not sure we have it right. We want to have a comprehensive review to see what kind of adjustments are needed in sentencing policy in this state. And so we've called upon the council and state governments to help us on that research. I've challenged them to dig deeper than ordinary, to give me more information to help us to make the right decision. We've also done another thing, and that is to enlist the help of the faith-based community. And so I called it the Hope Summit. I brought the faith-based leadership together, as well as the nonprofit organizations. We had over 500 organizations represented in my Hope Summit, and challenged them to address two problems that we face in the state of Arkansas. One was foster care, where we don't have enough foster parents for the children who are in need of care. It's something money cannot solve, but volunteers can help solve. And the second one was to give those who are reentering society, the ex-offenders, a better second chance at a new life. And so we've enlisted their support. We've challenged them, a tremendous response, because it will help the state to be successful. Those 500 reentry beds are expanded into new programs engaged in by the nonprofit leadership of our state. So that's our plan. Stay tuned. I hope for a good report down the road. Now, I talked about sentencing policy, and I'm going to give you an outline of the challenge that I face and that I think we all face. One of my responsibilities as governor and one of my powers is the clemency authority that I have under our Constitution. The pardons, the clemency power, it's a job that I take very, very seriously because it's a power that ought to be used under the right circumstances. It's not a power that should be put on the shelf, but it's one that has to be carefully used as well. And so my nightly reading are pardon files. And it's like reality TV. You're reading the file, you're reading the cases, and you see every kind of case in the world that comes before you. The vast majority are denied. The vast majority ought to stay in prison. But then you come across cases that make you wonder, well, was this sentenced right? Is this one that we need to change our sentencing law? Is there something we can do better? And I'll give you 4 cases to ponder on. One was a manufacturing marijuana that had booby traps around the enterprise. A little bit of danger there. This gentleman was given 5 years probation, no jail time. Around the same time in another county, case number 2, there was an offender that was a 2-time offender for drug offenses. So he was a dealer on 2 separate occasions. On the first occasion, he got 6 years in prison. On the second time he came up, he's a second-time offender, he got 40 years. Case number 3. Case number 3 is a 3-time drug offender. He offended once, he offended twice, he offended the 3rd time, and the 3rd time he was a habitual offender and he got 135 years. Case number 4. I'm moving away from drugs. Case number 4 is a gentleman who wrote $17,000 in bad checks. He got probation, and he was told not to open up a bank account. He went out and opened up a bank account. The judge was not very happy, and the judge sentenced him to 80 years in prison. So I have a case of a $17,000 hot check writer with 80 years in prison. And so those are 4 cases. Now, I tell you that because I believe in dealing in real-life circumstances. And you can analyze those in different ways, but in every one of those, you got to probe deeply into the underlying facts. But I think the questions I would raise is the 2nd time and the 3rd time offenders, the jump from 6 years to 40 years, the jump to 135 years, and contrast that to some of the other sentences that are given in our state by other judges. And my conclusion of this is that there's a lack of consistencies, and in some instances, there are excessive lengths of sentence. What is the solution? In Arkansas, we have a sentencing guideline system that carries some weight, but not enough weight. And this is an example, and you'll hear me talk about it, that I think the federal government does a lot of things poorly, even as though I'm a former United States attorney, and I have incredible admiration for the federal system. But I do believe they have it fairly close to right on the sentencing guidelines that are advisory under the United States Supreme Court cases, but they still carry sufficient weight to be persuasive with the courts and to provide them with meaningful guidelines. Arkansas needs to take another look at that and bring more uniformity in our sentencing, more consistency in our sentencing, and I look forward to the results of our task force to give us better guidance on that. And now let's move from the state system back to the days in my life where I dealt in the federal system, which has been fairly consistent actually through my career. I happen to believe that we do have a challenge with over-criminalization of our federal law. Let me just give you a simple illustration of that. I had a prosecutor in Arkansas that told me, you have our campaign finance reports that are given under state law. He says, I am afraid I might make a minor mistake in a finance reporting under state law, but I don't want to make it a potential federal violation, so instead of mailing them in, I'm hand carrying them in to deliver to the Secretary of State's office. Now you think about that. A prosecutor worries about a simple mistake becoming a federal case because of the mail fraud statutes. I think we need to review our federal criminal law. I think we need to review an effective speedy trial provisions in our law at the federal level. And I say that in the sense that I don't, they were written at a time which we did not have some of the discovery requirements that we have today. We need to review our seizure laws. That's a fair statement to make. Even though they've played a valuable role, it is fair to review those, and they should be. Our discovery process needs to be reviewed. And we had Senator Webb, United States Senator Webb, advocate that we have a review of our federal laws, but he combined it with our state systems. It need to be separated out. I advocate for a comprehensive review of our federal criminal system at the federal level for Congress to reconsider. And so I advocate today for a comprehensive review at the federal level, and I think at the state level, I can't speak for all the states by any means, but I do believe in Arkansas and probably other states, we need to have a more effective sentencing guideline programs to bring more consistency to our programs. Now let me end with this story, because I've talked about our criminal justice system. And let me tell you, it's the best on earth. It's got challenges. We need to fix many of it. But let me tell you about, if you come into my governor's office, you will see a jury verdict on the wall, which will be the last jury trial I'll probably ever have in my life. It was a jury case in Dallas, Texas, in which I was representing a gentleman by the name of Mohammed. Representing Mohammed before a Texas jury is a challenge. It's on very serious criminal charges, federal charges. And during the voir dire, the federal judge asked the potential jurors, now ladies and gentlemen of the jury, these defendants here are from the Middle East. Does that cause anybody any problems? And everybody shot up their hand and said, it's 9/11, these guys are responsible. My client turns to me and says, I'm Mohammed, I'm a Muslim, they hate me, I'm never going to get a fair trial. I said, I know they don't like you, but I think you've got a good defense, and let's give it a fair shot. So he proceeded with trial, 8 days of trial, 9 hours of jury deliberation, and acquittal on all counts. I like it, the defense attorneys applaud, the prosecutors are silent. But the moral, the lesson of that story, is not that anything but this, and that is that we have prejudices in our criminal justice system, but in America sometimes our sense of fairness overrides it all. And I still have confidence in our sense of fairness, the basic good concept that we have in our criminal justice system, even though it needs to be refined. Thank each of you for being here to refine something that is a very precious system in our Constitution. Thank you very much.